In our discussion today, it is compulsory for all businesses to submit to dispute resolution procedures under an industry code. What does that mean for your business? We will be joining Ian Jacobsberg of Anderson Global. So welcome back, everyone, and welcome to another live session of Franchising with FASA. If you have any questions or if you've got any comments, please post them in the comment box below. And yes, let us know where you're from, and welcome to today's show. Just to give you a little bit of a background of Anderson Global, TA Bax, founded in 1990, became a full member of the Anderson Global and has rebranded as Anderson, the South African member firm of the Global Association, with a presence in more than 45 countries in Africa and over 253 locations worldwide. Though his expansion efforts and unification of member firms under a common brand, Anderson now has the largest legal footprint in Africa on the African continent, offering its clients the power of a single touch point to manage legal and tax advisory matters as they invest and grow in the region. The firm advises on key regulatory and compliancy, transactional and commercial matters, specializing in competition law, corporate and commercial law, employment law, environmental law, franchising, intellectual property law, licensing and distribution agreements, litigation and dispute resolution, regulatory law, and tax law. So hello and welcome, Ian. Thank you for joining us today.
Thank you, Romney. It's good to be with you.
Thank you. And just to remind everybody out there, if you've got any questions, and please hit the like and share button and share this with anybody who may be interested in learning more about business, learning more about franchising, and and the legal side of franchising. So today we're going to be talking about the dispute resolution and what it means for our business. I don't know much about it, and that's why we have you joining us here today. So tell us, what is an industry code and what does it typically cover?
An industry code is something that's provided for by the Consumer Protection Act. The Act allows a particular industry to set up a code for itself, which would apply to people participating in that industry over and above the normal general application of the Consumer Protection Act. So it would impose a code of ethics, it would, and very often will also provide for a system of dispute resolution, usually under the auspices of an industry ombud. The idea of that is that you have someone who actually understands the intricacies of that industry, as opposed to a judge or arbitrator who may not be an expert in that industry, who will assist in resolving disputes.
Right. So like, for example, franchising, it's quite a specialist field, and not just anybody can kind of do franchise law. For example, so it's a very specialist niche. Correct.
And not only the law, certain industries have specific laws applicable to them, but then also the technicalities of the industry, knowing the products and knowing what is a good or a bad product in that industry, and what standards of service should be expected, etc.
Well, that's good. It's about time that we have a bit of industry coming together with a code. So where there is no industry code for a particular industry, how do consumers seek to redress against suppliers, and how do industry participants resolve disputes between them?
Well, right now, in terms of the Consumer Protection Act, there is the National Consumer Commission, which is a body that is set up under the Department of Trade and Industry with the mandate of receiving consumer complaints, investigating them, if necessary, then referring them to the Consumer Tribunal or to a court, or the parties themselves could take the matter to a court.
Does this apply to just products or business as well? So if someone owns a business, They can go to the Consumer Protection Act and complain about, say, perhaps that they're not happy with how someone is conducting their business?
Well, the Consumer Protection Act in general applies to consumer complaints. So there's no limit on who the supplier, so it could be any supplier of goods or services, no matter how large they are. But the consumer in general would have to be a natural person, in other words, an individual, or a business with a very small turnover, a turnover of over 2 million a year, which excludes most major businesses. So it is specifically designed for consumer complaints. The business-to-business complaints would generally be handled by litigation or arbitration in terms of whatever agreement governed that relationship.
Okay, so for example, if someone is a member of FASA, then it would be beneficial for those members to rather go through mediation process first, rather than going perhaps directly to litigation. It could reduce a lot.
Let me just. Sorry, Romy, I did not hear the end of that last question. If you can repeat it.
I was just saying that, for example, from our FASA members, and that's why people become members of FASA, so that in case there is a dispute, they can go for mediation first before perhaps seeking litigation.
Well, I was going to say there is one exception in the Consumer Protection Act in the definition of a consumer, and that is that a franchisee, in terms of a franchise agreement, no matter how large their business is also deemed to be a consumer for most purposes of the Consumer Protection Act. So whereas the general definition of a consumer requires that if it is a business, it has a turnover of under 2 million rand, when it is a franchise business, the franchisee is a consumer and has the rights of a consumer under the Act, irrespective of how large their business is.
Okay. And what is the effect of the recent High Court judgment on participants in the consumer goods and services industry, and what does it mean for other industries?
Okay, so what it means is that the Act is that there has been a judgment in terms of which parties involved in the consumer goods and services industry are obliged to submit to the jurisdiction of the Ombud. What happened in this particular case was that parties that were involved applied to court for an order that said that they were not obliged to contribute to the funds of the Ombud, and they were not obliged to submit to its jurisdiction, and that it was a voluntary process. The court held that that is not the case, that if you fall into the definition of that industry, then you're obliged to contribute subsidies to the funds of the Ombud, and you are under the jurisdiction of that Ombud. So that is a big jump away from, for example, the situation of most industry bodies, which are voluntary, and FASA is an example, where if a franchisor or a franchisee, for that matter, does not want to be part of the body and doesn't want to submit itself to the jurisdiction of the body, there's very little that the industry body can do. However, once the DTI has accredited an industry code for that industry and an Ombud has been appointed, then it is law that everybody who participates in that industry is subject to that industry code and to the jurisdiction of that Ombud.
Would that include non-members as well? I would imagine, just hearing what I'm saying.
Yes, well, that simply by virtue of the fact that you are participating in that industry. Now, for example, if you look at the franchise industry, the Consumer Protection Act has a definition that of a franchise agreement and has a definition of a franchisor and franchisee, which is the parties to such an agreement. So if two parties have concluded an agreement which complies with the franchise agreement definition in the Consumer Protection Act, then they will be subject to the jurisdiction of that ombud, whether either of them chooses to be a member of FASA or not.
Well, that is good news. I would imagine to a lot of businesses out there, and a good news for people to be able to comply to business ethics. Can I ask you, what are the advantages of mediation? For example, because, you know, a lot of people seem to seek, when they get into trouble, they go to litigation, which can be enormous cost factor. What is the advantage, for example, of having mediation that can save you costs?
Well, cost saving is only one aspect. It's generally the one that people do think about. It does have those advantages often. Sometimes it doesn't necessarily have that advantage because the process can be very lengthy and can be very and involve a lot of people and a lot of time. However, it certainly has an advantage from the point of view of particularly franchisees, because there is generally an imbalance of financial resources between franchisors and franchisees. And franchisees generally find it difficult to sustain litigation against particularly large franchisors. The benefit of mediation is that it's a voluntary process. And the main benefit is that in an agreement such as a franchise agreement, which is intended to be a long-term relationship, and like any relationship can hit difficult patches at times. The purpose of a mediation is to solve a particular problem at a particular time without necessarily destroying the relationship. Once parties have resorted to litigation, the relationship is probably over. What's happened at that stage, you're at a point where probably the franchisor has cancelled the franchise agreement, or the franchisee wishes to get out of the franchise agreement, so the relationship's over. In mediation, it's for the purpose of sorting out a problem during the course of the relationship, where perhaps the franchisor has an issue with the quality of service the franchisee is providing, or the franchisee has a problem with the quality of advice or quality of products that the franchisor is providing, and they just need somebody to assist them to see the other side's point of view.
And that often happens with people. It's so easy to get things misinterpreted or to misunderstand things. Can I ask you, are there any final thoughts that you have, or any tips that you'd like to share with our audience today with regards to either dispute resolution or mediation?
Well, just the first thing I just wanted to say is that FASA is in the process and has been in the process of attempting to have an industry ombud accredited. When that happens, then the situation that I described, where all participants in the industry will be subject to that ombud, will then all participants in the industry will be subject to the ombud, and the code will become law. In the interim, it is always advisable, if parties can resolve their differences without resorting to litigation, that they do so. And mediation, which FASA offers as a facility to its members, is always a good option if the parties are interested in continuing a relationship for their mutual benefit.
That makes sense. That makes sense. All right. If anybody wants to find out more about how any of the legal services that Anderson Global and yourself offers, how can they get in touch with you?
Well, they can look at our website, which is za.anderson.com, and all the contact details are there. My office telephone number is Johannesburg code 11-358-7745, and I'm available anytime.
Thank you so much, Ian. And if anybody wants to get hold of you, thank you. And if anybody wants to get hold of Ian as well, what we'll also do is pop a link to their listing in the comment box below, so that you can also click there to get hold of them. Just once again to remind you in closing that FASA is an organization, which is a non-profit organization, which is there to protect, lobby and promote ethical and to develop ethical franchising across all sectors in South Africa, with a specific focus on transformation. If you'd like to find out more about membership and other services that FASA offers, for example, the manuals and events that we host and anything related to franchising, you can visit FASA at www.fasa.co.za. Thank you for watching and have a super day further.